men and women. In March this year, the lawyers for the Unibank directors and shareholders approached me with a proposal of their clients' intention to settle their indebtedness to Unibank. In response, I convened a meeting on the 25th of March with them, their legal representatives, and the receiver of Unibank, Mr. Ni Amano Dodu. At the meeting, it became obvious to both parties that a reconciliation of Unibank's account with the Bank of Ghana should be conducted. Therefore, I authorized the receiver to engage in the reconciliation exercise with them to determine the full scope of Unibank's exposure. I directed that the parties adopt a holistic approach that combined liabilities under both the criminal proceedings and the ongoing civil proceedings, because they were obviously interrelated, in order to reach a unified resolution that will bring closure to all related matters. The objective was to assess the feasibility of a comprehensive settlement. The charges in the criminal case against the accused persons involved a total amount, and this is very important, a total amount of 1.2 billion Ghana cedis, not 5.7, as is being bandied about from certain quarters whose names I would not want to mention. While the civil case involved a total exposure of 5.7 billion Ghana cedis. Now, ladies and gentlemen of the media, if you conduct your research in the High Court, you realize that the receiver subsequently amended the writ of summons and the statement of claim and revised the civil liability down to 2.8 billion Ghana cedis. Okay, so that is on record. That's a public record, and whoever wants to contest this is at liberty to go to the High Court and then, do so. It is important to state for the avoidance of doubt that the total exposure in the criminal case is part of the total civil case exposure. In other words, the 1.2 billion is not in addition to or on top of the 5.7 billion, which was revised down to 2.8 billion. The 5.7 billion was made up of the following, that is from the initial stage of the case. 2 billion being loans and advances which Unibank made to related and connected parties. 3.7 billion being payments made on behalf of or on the instructions of the accused persons. Included in A and B above, however, was an amount of 2.1 billion which was alleged to be fictitious loans, to have comprised fictitious loans and fictitious transactions booked by Unibank prior to replacement in official administration. During the reconciliation exercise, the accused persons objected to the inclusion of the 2.1 billion on the grounds that the amount did not involve any direct cash outflows which could be recovered. The accused persons also objected to the inclusion of placements of 0.3 billion, that is 300 million, made to Unisecurities. Now, Unisecurities is a Securities and Exchange Commission regulated, not a Bank of Ghana related company that had been placed in liquidation and for which a claim had been filed with the official liquidator. In other words, the money was to be recovered. The recovery of this amount is being pursued independently through insolvency proceedings with the official liquidator of that entity. In summary, the above matters led to the revision of the previously reported exposure of 5.7 billion down to 3.3 billion.